Hey everyone, as promised, I'm finally making your final video for Unit 3. I finished a day of school. I took the kids 45 minutes away to dance and then another 45 minutes away to gymnastics after driving 45 minutes from school. And here I am. Here I am to convey the end of this unit for you guys. So we're going to start off with balancing majority and minority rights. Please remember, and I say this often, when we talk about minority here, don't think of like racial minorities. Okay, remember we learned about Madison writing about minority rights in the Federalist Papers. So just think of a minority group which with an opinion which could be race, but could be a plethora of other things. So how does the balance happen from the court? And there's a lot of ways that the court interprets the Constitution and other things when coming to their conclusions. So what matters? Judicial philosophies matter. Precedent of stare decisis matters. Judicial appointments and the confirmation process matters. The cases that are actually on the court docket, what are they choosing to interpret matters. And amici briefs as well. So let's look at some examples here. We've been learning this week more about Brown v. Board of Ed. And what's the big case that it, in some ways, overturned, right? There's a different interpretation here, and that's Plessy v. Ferguson. And Plessy v. Ferguson thought that separate but equal was legit. And Brown versus Board of Ed was interpreted that no, separate but equal is in no way legit. So in Plessy versus Ferguson, you have equal protection under the law is denied, whereas under Brown versus Board of Ed, equal protection is given. And there's two quotes here, and it shows you the changing of interpretations. One of the quotes from the majority and Plessy versus Ferguson said, "If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put the construction on it." Like, it's, if we separate the races and treat them equally, we're not treating one inferior. It's their fault if this makes them feel inferior. And Brown versus Board of Ed was like, go, time out. That makes no sense, right? Obviously, just the structure alone generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely to be done, right? Like, there's damage here when you put kids in schools like this. And I know when we saw the crash course video, it mentioned that there was an overlap of Brown v. Board of Ed and the Cold War and the fear of communism at the time. So when I came across this picture, the idea that race mixing is communism, like, I was like, oh my gosh, the ridiculousness. I had to share that with you guys. So how do judges, where do they get their interpretation from, right? There's all different ideas. There's the fixed meaning, like you should interpret it the way they meant at the time, versus more different evolving theories. So you have like the static opinion of the Constitution versus the dynamic. And how does these different views balance majority rule versus minority rights? Okay, there has been rules over time, decisions over time that have contracted minority rights, and there's been some that expanded these rights. So an example of contracting minority rights is Crawford versus Marion County Election Board. And this is from 2008. This is recent. This is in Indiana. And it basically said that requiring a photograph to vote was not a poll tax. All right. So it made it a little bit more difficult to vote, contracted those minority rights, whereas others throughout time, 1966, Harper versus Virginia Board of Elections, saw a voter ID as a type of poll tax, and that violated the 24th Amendment, so you can't do it. Other examples of expanding minority rights is Loving versus Virginia, and we discussed that earlier, because before this in Virginia, before this ruling in 1967, it was like illegal to have an interracial marriage. 1967, right? Like all these crazy laws that were around not long ago. All right. So we see over time different forces that expand and different forces that constrict. We also want, I know a lot of these examples I'm using do involve race, but I'll try to show you here, right? Like the poll tax wasn't necessarily a racial thing. That could be a class thing, right? Often the factions are rich versus poor. That's probably one of the biggest factions that Madison thought of back in the day. All right, so now we're going to look at affirmative action briefly. I thought I had a definition of. Oops. Okay. So let me jump to this first. Look at that box in the bottom. So affirmative action is not one specific thing, though it's often just looked at as one specific type of thing. But it's any series of laws, executive orders, or court decisions that favor individuals belonging to groups that experience discriminatory practices before the law. And there's different ways this can happen. You can have passive court actions, which means Congress over time has grown more powerful, right? It sort of has grown beyond what the founders thought the powers of Congress would be. So, what ways can the judicial system at times keep that in check? And that can be from judicial nullification, judicial negating, or even just voiding, like this law is unconstitutional. Now, as much as I'm not a huge fan of these AP videos on this, and I guess you guys agree, I did like that they included this quote from Oliver Ellsworth. Now, he was helping to frame the Constitution, but this is after it's written. It's during the constitutional ratification process. He helped with like Roger Sherman create the Great Compromise, the convention. So he really wanted it to pass Connecticut. And here he says the Constitution defines the extent of the powers of the general government. If the general legislature should at any time overlap their limits, the judicial department is a constitutional check. If the U.S. goes beyond their powers, if they make a law which the Constitution does not authorize, it is void. And the judicial power, the national judges who, to secure their impartiality, are to be made independent, will declare it to be void. Right? So, once again, just pointing out what is the role of the judicial branch, right? Even though it was the smallest part of in the Constitution of all the branches, this would act as a check to Congress. Now, what they don't mention, and I want to give you a little history here, is that Ellsworth actually became, he was a senator. And as a senator, he did things to try to expand judicial powers. He was such like, a believer of this. I don't know how much I want to get into it with you guys, but he helped create the Judiciary Act of 1789, which really helped the structure of the federal court system. And he himself was the third Supreme Court Chief Justice. And he did things there to try to expand it as well. Not a whole lot in his limited time, but you see how that was important to him. All right, so besides a passive court system, you can also have an active court system. Judicial review would be an example. That's more active, right? Congress actually grants certain powers to the courts, right? How did the courts gain these powers? Well, based on their independence, right? Their independence of parties and of structure, of stare decisis and other precedents, and just how things have evolved, right? It seems like everything has grown more powerful and when you look at these branches. All right, so first off, that's something to keep in mind, is the ways the court system can use their powers, right? But the court system is not the only authority when it comes to things like this. There's many sources of authority that take action and refer to affirmative action, right? There's laws that Congress can create. So the Equal Pay Act of 1963, right? The Civil Rights Act of 1964, the Americans with Disabilities Act, right? So affirmative action is, first off, not just race related. So people with disabilities, it could also be gender. That's right. So different laws that Congress passes. Then you have executive actions. We mentioned some in the last, I believe it was the last video. You have executive orders 8802 and 9901. I think we discussed 8901, right? Those ones I mentioned for FDR, right? No discrimination in hiring in government contractors, and then the Defense Department, and then Truman desegregating the military, right? You also have court decisions. So the court can act as well. I've already mentioned to you guys United States versus Virginia in 96 when VMI was not allowing women into their military academy, and SCOTUS was like, yeah, not so fast, guys. That's not cool. All right. You also have Reed versus Reed. And I have a little memorial outside of home here. Reed and her husband lost their son. And if I'm remembering the story correctly, when it went to then like retrieve his property, they went to say like, well, who sort of gets like, who is this going to go to? And the courts are like, well, it always goes to the man. Like they're the first in line. And Sally Reed was like, well, that makes no sense. Right? Even when I went to buy a home years ago, they were like, oh, we always put the man's name first. I'm like, well, I'm alphabetical order. So why is this? Right? Why are some of these things exist like this? So this case said to give a mandatory preference to members of either sex over members of the other merely to accomplish the elimination of hearings on the merits is to make the very kind of arbitrary legislative choice forbidden by the Equal Protection Clause of the 14th Amendment. And whatever may be said as to the positive values of avoiding intrafamily controversy, the choice of the context may so blah, blah, blah. Like this violates the Equal Protection Clause, right? So people often think affirmative action in just schools and race, but it's much broader than that. And to help any discriminatory policies be, have there are some effects be mitigated. Like I said, also coming to gender, disabilities, so on and so forth. So there's a few specific cases to look at when you see how this has evolved over time. There is the case Regents of the University of California versus Baake. And I hear Baake was rejected 2 times from UC Davis Med School. He's not much known about him. He's sort of kept to himself. As far as I know, he has not since been killed in a bar like many of our other Supreme Court people. He was in his 30s. He worked at a NASA lab. He was a Marine Corps veteran. He's trying to get into med school. He's rejected twice. And he gets mad when he realizes that 16% of all the seats at this med school were reserved for qualified minority candidates. So he sued. He said, this violates the 14th Amendment Equal Protection Clause because my rights are not being protected. So it's interesting that there's some wins and losses on both sides here, I guess, depending on how you look at it. The majority opinion said race can be a factor to promote diversity in education because diversity in education is a compelling state interest. Remember, it had to pass this in order for certain factors to be put in, like race, gender. You have to pass that strict scrutiny test, and one is compelling state interest, and this definitely did. But it has to be along with other factors as well. The dissent said race can be a factor, and it won't violate the 14th Amendment. So what's interesting about this case is that there were, even for those who agreed in the ruling, of the 9, there's 6 different opinions that came out of it. So they all sort of interpret it. I shouldn't say all, but there were several different ways that it was interpreted. They said, certain quotas might be permissible or may not be permissible. So you can't really have a quota, but you can have race be a factor. So part of it is okay, and part of it wasn't okay. Long story short, he did end up going to medical school, even though this was upheld. Part of it was upheld, and I think he became an anesthesiologist in Minnesota. All right. So here's two opinions of this case. So Powell said the guarantee of equal protection cannot mean one thing when applied to one individual and then something else when it's applied to someone of color. If both are not accorded the same protection, then it is not equal. And Justice Blackmun looked at that completely different. See, Powell, it's what's called the colorblind theory. And Blackmun was like, this colorblind theory of the Constitution makes no sense. Because in order to get beyond racism, you first have to take race into account. Like, if we want everyone treated equally, you have to see where these inequalities have lied, not just in the past, but currently, and to adjust and overcome for them. So he said there is no other way. And in order to treat some persons equally, we must treat them differently. Right? My parents used to say, well, we would treat you differently, but it all had the same goal because you're different children, right? And it's not exactly the same, but the idea is that you need to take these things into factor, right? So, and this is the big power sentence here. We dare not let the equal protection clause perpetuate racial superiority. So reflect on that. How can you say, well, because I have to treat these people the same, if it's going to end up actually reinforce a race treatment of superiority over another, is that really equal protection? Right? And let's look at Thurgood Marshall's opinion here. Dive into this more on your own if you get a chance. That's a screenshot there of his actual notes of the case. Now, remember, we already learned that Thurgood Marshall was a lawyer for Brown v. Board, right? And he was the first African American on the court, one of only two. He was there until 91. And then we have Clarence Thomas, who is still on the bench. Maybe we'll have a third one in a few months. Be a woman this time. That's what they say is going to happen. But anyway, he looked at the context of the history of the Constitution and said this Constitution did not protect these minorities in the past. Don't use it as a loophole as to prevent their protection now, right? So he also referred to Plessy versus Ferguson, right? Which of course he had to be super familiar with, being the lawyer for Brown v. Board of Ed. So he says if only the principle of colorblindness had been accepted by the majority in Plessy in 1896, we would not be faced with this problem in 78, right? In the 60 years from Plessy to Brown, ours was a nation where by law individuals could be given special treatment based on race, right? Segregation was legal. For us now to say that the principle of colorblindness prevents the university from giving special consideration to race, when this court in 1896 licensed the states to continue to consider race, is to make a mockery of the principle of equal justice before the law. All right, and another line from his opinion is, these differences in the experience of the Negro make it difficult for me to accept that Negroes cannot be afforded greater protection under the 14th Amendment where it is necessary to remedy the effects of past discrimination. So based on, right, obstacles they face unequally, the 14th Amendment might need to be expressed a little bit differently to try to get to that goal of complete equal protection, right? So let's look at some more recent cases. We have Grutter versus Bollinger and Gratz versus Bollinger. These both deal with the University of Michigan. I use this image because there is the date on it, so I said that will help it stick here. 2003 and 2008. These were some case law studies. These are known as the twin cases. They both dealt with the University of Michigan. Grutter versus Bollinger was a law school, and race was used there in admissions, and it was agreed that it could be used as long as it was used holistically. It was used as one of many factors, and that would pass the strict scrutiny requirement, right? It could not be the principal or the primary factor for admission. It could just be one of many in a holistic admission. And once again, not a quota, right? Gratz dealt with undergraduates, and it said all qualified minority students or underrepresented students would be allowed in. And this was not permissible because this made race too much of a factor. So it did not pass strict scrutiny. It failed it, right? So you see the difference here. And then Fisher versus UT Austin 1 and 2. I believe that's 2013. We can check, but it's definitely more recent. And here it said that the top 10% of every high school in the state would automatically be accepted. Or maybe it was the town, but it was this part of Texas. So if you were in the top 10% of your graduating class, you automatically would get in. Well, you might be 20% in one school, and you might think you have a better portfolio than someone who is 10% at their school. But remember, after Brown v. Board of Ed, we said even though segregation is now illegal, there's still segregation as far as where school districts are located and how they're funded, and different opportunities that those students have based on those criteria. So that's one significant way to combat that, is that if you are still in the top 10% regardless, right, you rise to that position, you get automatically in. Then all the rest of the admissions, race is just a factor, right? It's not, once again, like a quota or a singled out factor. Okay, so it passed the scrutiny test as concrete but not a rigid goal, right? You're trying to end the informal segregation of schools these days. We're going to look at later this week cases that are coming up that are on the docket now for SCOTUS, and I just sort of screenshotted this from the SCOTUS blog. That way you can see the author. But court will hear challenges to affirmative action at Harvard and the University of North Carolina. It says here the cases are Students for Fair Admissions versus President and Fellows of Harvard College and Students for Fair Admissions versus University of North Carolina. The court consolidated them for oral argument, and they likely will be argued early in the 2022-23 term. And this has to do with some schools battling things that some ethnic backgrounds actually get advantages based on certain things. Mainly, how do you combat if you base mostly on test scores and you have an overrepresentation of Asian students, right? So we'll read these articles, we'll discuss them, and there'll probably be more cases in years to come, and we'll see how the courts continue to evolve and interpret, and where we see due process, where we see equal protection, where we see all these things we're learning about. All right, so see you soon, guys. Time to work on the kids' homework.